2008 में RY के कॉलेज नासिक से उन्होंने अपनी डिग्री प्राप्त की। उसके अलावा इन्होंने बहुत सारे सर्टिफिकेट और डिग्री कोर्सेज, इन्होंने पेटेंट लॉ, पेटेंट पे किया और आज वो रजिस्टर्ड पेटेंट एजेंट हैं। साथ ही इन्होंने LLB फ्रॉम YC लॉ कॉलेज पुणे से उन्होंने प्राप्त की। इसके अलावा इनकी जो स्किल्स हैं वो स्किल्स है पेटेंट ड्राफ्टिंग ऑफ पेटेंट, जो कि एक बहुत ही इंपॉर्टेंट एस्पेक्ट है। साथ में ट्रेडमार्क सर्च एंड एप्लीकेशन, रिस्पॉन्स टू एग्जामिनेशन रिपोर्ट ऑफ ट्रेडमार्क एप्लीकेशन, GI ज्योग्राफिकल इंडिकेशन एप्लीकेशन एंड रजिस्ट्रेशन। इसके साथ ही इन्होंने अपना डॉक्यूमेंटेशन कंप्लीट किया है GI एप्लीकेशन फॉर जलगांव बनाना एंड जलगांव ब्रिंजल। Apart from this, she has done country coverage and assignments information analysis, also in validity research, business information search, FTO analysis. So this is the all about a brief introduction of ma'am. So I'd like to invite Kshitija Kulkarni ma'am to present her ideas regarding IPR. Welcome, ma'am.
Yes, thanks a lot, madam and sir, for my introduction. So without wasting any time, I guess I'll now share my presentation so that we can start. Is it fine? Am I audible to you?
Yes, ma'am.
Okay. If I'm not audible, please let me know in the middle so that you know I can.
Of course,
okay, so I'm sharing my screen. I hope you're able to see the screen.
Yes, ma'am.
Okay. Just a minute. Oh. So basically now intellectual property. So as the topic says, intellectual property rights and IP management. Basically, how you are supposed to see. Just having intellectual property rights with you is not enough. You should also be able to enforce your rights. You should also be able to exploit your rights, because even if you have patents, even if you have very good trademark folio, patent folio, what is the use of it if you're not using it? Okay, so how to monetize it? So that also we are going to see. So let's start with this. So just a brief introduction about IP and IPR. So what exactly is IP? IP is nothing but intellectual property. So what is intellectual? Intellect itself suggests that something which is created by our mind. Okay, something which is created by our human mind, by our human intellect. Okay, so the rights which are covered under the umbrella of intellectual property, they are known as intellectual property rights. So few important things which you should be aware about IP rights is that this is the intangible property. So what do you mean by intangible property? There are two types of properties, that is tangible property and intangible property. So tangible property means in the physical form. Say for example, the document. So document is a physical form which can be handed over from one person to other person. So that is why it is known as a tangible property. Okay, so intangible property means what? It is not having any physical appearance. Okay, so that is an intangible property. So all the rights that are under the umbrella of intellectual property, they are all intangible property. Okay, second, these rights, they are exclusive rights. So what do you mean by exclusive? That you are preventing others from using those rights. Okay, so you are having the monopoly, you are claiming your exclusivity. Okay, so you are the owner of that particular property. Next is a territorial right. This is very, very important, that all sort of intellectual property rights, they are territorial in nature. Territorial means what? If you are applying for any of the right in Indian jurisdiction, then you will be seeking, you will be having that particular protection in only India. If you are willing to apply outside in India, of course, there are different ways and means through which you can apply outside India. But you have to keep in mind that it is a territorial right. So if you are applying for patent, okay, in the Indian Patent Office, so you are going to get the protection. You can claim the monopoly over that particular invention or innovation only in the Indian jurisdiction. Okay, so that is very important, that all types of intellectual property rights are intangible assets, exclusive rights, and territorial rights. Okay, so this is again a brief different types of intellectual property which are under IPR. So those are patents, geographical indications, trademark, trade secrets, industrial designs, then plant varieties, semiconductors. So there are n number of rights that are included under intellectual property rights, out of which we will be focusing on the few which are related to startup and all. Okay, so now before entering into the IP facets in startup, let us first understand the startup system in India. Before this, a very brief introduction about what exactly is a startup. Okay, so startup is a company. So what are the conditions which are required for your company to be considered as a startup? So your company can be considered as a startup only when it is less than 10 years old. So 10 years are not over since the incorporation of that particular company. Okay. Secondly, the turnover of your company should be less than 100 crore in each financial year. Thirdly, which companies can be registered as a startup? Those should be a those can be a limited liability partnership, those can be a partnership, or those can be a private limited company. Proprietorship cannot be considered as a startup. Okay, so these are the three, and the main objective of the startup system is the scalable growth or a scalable business model. You should be able to bring the business model or a solution to a particular problem which is not existing in the current market. So that is a unique business model which will lead to the creation of employment and indirectly to the generation of the wealth. Okay, so that was the main objective of the startup system in India. So these are the different criteria for startup, and now the startup ecosystem in India, that it was launched by the government long back in 2016 with again objective to promote entrepreneurship and to create jobs and this again employment. Okay, so the emphasis was given on Make in India and Atmanirbhar Bharat. Okay, so what does it mean? That Make in India means manufacture the different products in India itself, so that their cost will be also less and it will be fruitful for all the citizens of India instead of importing the things or products from other countries. It is better to manufacture in India itself. Okay. Then, as I said, through innovation, scalable business model. So what do you mean by scalable technology? Scalable technology means there is a proper growth. There should be a growth in that. Okay. So scalable technology, startups can generate impactful solutions. Okay. So by bringing new solution to the current technical problems, you can definitely go and start up your particular company and register it as a startup under our Startup India portal. So on that particular portal, it is a government portal. You are supposed to register your company, but it is not mandatory to register. But when you register that company, you can get the privileges of certain schemes, okay, that are available via government. So government is supporting a lot to develop this startup culture. How it is supporting, we will see a bit later. Now, role of IP facets in startup ecosystem. Now, let us see few rights what are there. So these are patent is the first one. So patent. So for what actually the patent is granted? Patent is granted for invention. Okay. So if you are having a particular idea in your mind, okay, and when you are converting that particular idea into a particular product, then that product can be applied for a patent, or you can get a patent for that particular product or for that particular process. Okay, so converting what is the role of startups in this era now, that they are converting their ideas into the invention and then they are protecting their invention in the form of patent. Okay, so invention is nothing but a new product or process involving inventive step and capable of industrial application. So what exactly is a patent? So patent is nothing but techno-legal document. Why techno-legal document? So techno-legal, what does it indicate? That for technical data, okay, for your technical invention, you are having a legal protection, and that is why it is a techno-legal document. So there are few criterias, okay, which have been set by the government, okay, to get your patent granted. So what are those criteria? They are novelty, inventive step, and utility. So novelty means what? That your particular invention has not been used priorly, it has not been disclosed to anyone priorly, it has not been published priorly. So it is not priorly known, it is not priorly used, and it is not priorly published anywhere. Okay, then and then only it will meet the criteria of novelty. Second is inventive step. Inventive step means what? Something new to the existing invention. Okay, so that is nothing but inventive step. Means what? Having technical advancement. Okay, enhanced efficacy, technical advancement, and which is of economic significance. Okay, so that is nothing but the inventive step. And the last one is the industrial application. Of course, it should be utility. I mean, it should, you must be able to use that particular invention in the industry. And once the patent is granted, you will get that patent grant. You can enjoy your monopoly right for the period of 20 years. So 20 years from the date of filing of the patent application. Okay, after 20 years, your invention is going to come in the public domain. Means what? You cannot no more can claim a monopoly over that particular invention. So you can exploit your invention to the fullest in these 20 years. Okay, so the patent system in India is governed by our Patent Act, which has been amended this or gradually. Now, what are the rights of inventor on grant of patent? Okay, fine. You have applied for patent. You have received that particular patent. Next, what? So these are the rights of inventor. So once you get a patent, these are the rights which you can enforce or you can enjoy these rights. Okay, so what are the rights? First one is to use. We will start from right side. First one is use. So the inventor, who is also known as patentee, to whom the patent is granted, he is the patentee. Okay, so patentee, he can enjoy, he can use his patent, he can use his invention in whatever manner he wants to. Secondly, he can make or he can manufacture his product or process in whatever manner he wants to. Then he can even sell his product or process. He can offer for sale. So he's offering some third party to sell his product or process. Okay, next is to assign. So what do you mean by assign? Assigning means you are transferring your rights. We'll see this in the next slide also in detail. Licensing. Licensing means what? You are giving permission to use your invention for a specific period of time. Then is surrender. At any point of time, you can surrender your patent whenever you want to in the Indian Patent Office. Okay, you have to apply accordingly to the controller. Then is file for infringement suit. This is very important because if someone else is using your patented product or process without your permission or without your knowledge, you can definitely sue that person for patent infringement. Okay. Then trademarks. Now, what are trademarks? As you must be knowing, the symbol or the, sorry. So these are the specific symbol or these are the specific logos or these, it might be specific numerical. We'll take the example. Next slide gives the example. So these are the trademark this. So what are these? See, like patent, it is again a very important type of intellectual property. So basically, there are different again criteria for trademark registration. Those are distinctiveness, and they must be able to you must be able to represent that particular trademark on the paper. So that, see, basically you are whenever you are applying for a trademark, you have to submit few documents to the trademark registry. Okay, so at that time you must be able to represent that particular trademark graphically, and your particular trademark must be distinctive. Distinctive means what? It should be original. It must not imitate anyone else's trademark. So these are the very famous or the well-known trademarks. You can say Coca-Cola, Adidas. From logo itself you can understand like which company is the owner of that particular mark. So this is very important. But the basic difference between trademark and patent is trademark protects only the logo, and patent, it protects the functional aspects. Okay. Now these are the trademark symbols which are usually used: TM, SM, and R. So you must have seen many a times that above that particular logo you might be seeing either there is a TM symbol or there is a SM symbol or there is a R symbol. TM indicates that that particular company has applied for trademark, but its trademark has not been registered yet. So it is in the application stage. Means they have applied that, but it is still, so registration is still in process. So in such cases, usually the TM mark is used. Then SM. SM mark is specifically used for the service mark. So service providers. So they use SM mark, and R is the mark which is used when your trademark gets registered. Then you can use the R symbol above your mark. Then are industrial designs. So what are industrial designs? These are again important aspect of IP because they protect the aesthetic appearance or the ornamental pattern of a particular product. So whenever you are having a particular product, okay, the functional aspects of that particular product you are definitely going to protect under patent. Okay, so the name of that particular product you will be protecting under trademark, but the shape of that particular product, okay, how it is appearing aesthetically, how it is there, so that particular appearance can be protected or that can be registered under Industrial Design Act 2000. Okay, and for industrial designs also the basic criteria is that it should be original. You should not copy it from the others. Okay, I'm just taking these IP aspects. Why? Because you can understand that how they are going to play important role in startups further. Okay, that is why I'm introducing these IP aspects. So next is the copyright. As you must be knowing, so it grants the protection to composers, computer programs, then to authors, then also legal protection for literary, artistic, dramatic works. So all the computer programs, as you know, that computer programs or softwares, they cannot be protected under patents. So under Section 3 of Patent Act, there are few inventions that cannot be patented under Patents Act. So these are the non-patentable inventions. So computer programs or the source code, you can say, or the algorithms, they are not patentable under the Patent Act. So if your invention is related to that, then the technical aspect or the process aspect you can protect under patent. But the proper computer programming or that source code or algorithm, you will have to seek protection through copyright. So that is why it is also one of the very important aspects of IP. So again, copyright is for the limited period. And what is copyright? Copyright is nothing but the way in which you are expressing your ideas. Okay, so functional aspects are not considered under copyright. Only the way of representation of a particular information or way of expression of ideas can be only protected under copyright. I forgot to tell that trademarks, they can be once registered, they are you can use that trademark for 10 years, and after 10 years you have to renew that trademark. So it will be valid for 10 years. Like patents, they are valid for 20 years, but after 20 years patent or your invention comes in the public domain, you cannot claim right after that. But for trademark, once you apply for trademark and your trademark gets registered, then you can use your trademark for 10 years. Okay, so its validity is for 10 years, but you can indefinitely renew that. Okay, so whenever you renew that, it will get renewed for next 10 years. Like that, you can renew it for indefinite times. Okay, and for industrial designs are again the lifespan of industrial design is for 10 years. You can renew that. After that, you can renew for 5 years, but after 5 years, you cannot renew further. It will come in the public domain. So total span for which you can protect the industrial design is 15 years. Okay, copyrights, there are again different number of years for copyright. It is usually 60 years plus the lifespan of that particular author. That is usually the number of years for which you can protect your copyrights. Next is trade secret. This is again really very important aspect, because many a times it happens that a particular person or a particular invention, he might not be willing to disclose his say process or his maybe formula or maybe method or maybe recipe. It might be anything, or it might be drawing. So at that time he is keeping that as a trade secret. But the very important or valid point is that he must take utmost care while keeping a particular thing or keeping a particular process or product as a trade secret. The best example of the trade secret is this Coca-Cola. Okay, so the composition of Coca-Cola, no one is still knowing the composition. No one is still knowing the recipe, how it is made. Coca-Cola, it is known only to 2 people. They only know how it is made. So you can imagine the Coca-Cola is such an old product, and what measures, what preventive measures they must have taken to keep this as a trade secret, because keeping recipes usually as a trade secret is not that easy. Okay, next example is even KF chicken, that masala is used for KFCs. That again is a trade secret. Okay, so they have to take a very preventive measures to keep a particular information as a trade secret. So that is nothing but the information which you are not disclosing to anyone. So these are the precautionary measures which you are supposed to take for the protection. So what are there? It should be shared to limited number of people. Whenever you are sharing that, you should sign the NDAs with those people. You should draft the clauses accordingly, okay, to bind those people in that particular NDA. You should restrict the access to these databases, servers, or computers which is having that particular information related to trade secrets. Okay, and whenever you are handling or giving any document to someone confidential, you can definitely put a watermark or a label as a confidential, so that the person to whom you are giving that, he also understands, fine, this is a confidential and he is not supposed to share that information with anybody else. So these are the precautionary measures. So what is the basic difference between trade? Now, what is the basic difference between patents and trade secrets then? Because patent is also granting you the protection for 20 years, while the main this, you can say, advantage of trade secret over a patent is that patent can be granted only for limited period, that is for 20 years. After that, you cannot claim your right or claim your monopoly. But for trade secret, it is going to be protected for unlimited years, provided it is your secret is not coming in the public. Once your secret does not remain confidential, then you cannot claim a protection over it. Okay, so that is the advantage of trade secret over the patent. Why? Because see, there is no there is no need to file any application. You save a lot of money in that. Basically, you are not spending anything, right, for application for trade secret. So usually what we recommend is that you keep a particular invention, you keep a particular product or process as a trade secret, which is having less than 5 years lifespan or something. See, now there are few computer programs or few inventions, that after 3 to 4 years, people are going to know about the process, how it has been made. So at this time, it is always recommended to keep it as a trade secret. However, whenever you know that it is going to have a long-term effect, at that time you should go and apply for patent. Okay, so that is usually we recommend our clients that trade secret, because once that secret is leaked, then you cannot claim a protection over it. So depending upon the, what is the outcome or what is the effect of that particular secret, or how much, you're going to gain for it. So depending upon the technology, depending upon the information which you are going keeping as a secret, it totally depends on that, whether you're supposed to keep it as a trade secret or whether you are supposed to go and register it as a patent. So it is up to you. Now the important part. Fine, now you are having everything with you. You are having, copyright. You have applied for copyright. You applied for industrial design, trademark, patents, everything. And you have also got all this thing registered for your particular product. What next? That is just not enough that keeping a particular IP portfolio. You have to also exploit that. You have to also convert that particular intangible asset into money. So how you are going to do that? So these are the means of commercialization. Okay. So licensing. So what you can do, so if you are having any type of IP, okay, what you can do, you can license that. So licensing, you are giving permission to use that particular technology for a specific period of time. So in this case, you are the owner of that particular technology. Okay, you are not transferring your rights. You are just giving permission to third person to use that particular technology for a specific period of time. Okay, so the main criteria for this, it should be registered. There is a licensing deed. Okay, in that particular deed, all the clauses are properly mentioned, that what are the rights which are giving, which the licensor is giving to licensee, then for how many years this licensing deed is going to remain valid, and if there is any breach of contract, then what are the disputes, what are the remedies which we are going to seek. So all these clauses, the claiming of ownership and all these related clauses, they are mentioned in the licensing deed, which is signed by both the parties. Okay, so there are different types of licenses. The owner of the patent or owner of IP, he can give different type of licenses. First one is exclusive. So exclusive license means what? He is giving the exclusive license means what? The person to whom or a company to whom that particular owner is giving the exclusive right, that company can only manufacture or use that particular product. Okay, even the owner also cannot use that particular product. Why? Because that company is the exclusive person. The word itself indicates that exclusive means what? The licensee who has been granted the exclusive license. In this case, even the owner or the patentee, he cannot claim or he cannot use that particular patent. That particular licensee is the only person who is going to use that particular patent. So that is why usually this exclusive license is not practiced. Non-exclusive license is practiced in the market. Non-exclusive means what? You can give license, the owner of the IP can give license to n number of companies, n number of third parties by just signing and registering the licensing deeds, and he can enjoy the royalties. So what is the basically use or what you are going to get by licensing? You are going to get a money. How? Because you are going to get a royalty. That might be monthly, that might be quarterly, that might be annually. Again, it totally depends that the person to whom license is being given, it is going to give, he is what exactly that how much amount is going to give as a royalty, that all is decided in that particular licensing deed contract. So it is one type of contract which has been signed between the two parties. Okay, and all the clauses are mentioned related to licensing, wherein the owner, he can sit and enjoy his products by giving them in the way of licensing, and he can get a money from that. Okay, next one is joint venture. So what is joint venture? When two companies, they want to use a particular set technology, right, for a particular purpose, so they will just come, they will form a joint venture for a particular purpose, and when that particular purpose is served, they will again separate themselves. So that is nothing but the joint venture. So by forming a joint venture, converting, so what they can do, see, two companies, both are having their own two patents, but you know, these patents are like that A company is in need of B company's patent, and B company is also in need of A company's patent. So at this time, the two options are, they can either form a joint venture and they can enjoy their both IP right. Again, there is a contract between these two parties. Secondly is a cross licensing, which is being followed in many IT companies. Cross licensing means what? I will give you my license, you give me your license to use a particular technology. So this practice is also being followed. So you can either form a joint venture and earn the money out of it, or you can cross license your technologies. Then is assignment or sale of rights. So assignment is nothing but you are completely transferring your rights to the third party. Means what? That you now are no owner, or you cannot claim yourself as a patentee or owner of that particular IP right. You are assigning your rights. Means what? You are completely going to transfer your rights. So once your rights are transferred to that particular third party, the name of that third party is going to be entered in your patent register or say trademark register. So that is going to be the new owner of that particular IP. Okay, you won't be the owner of that particular IP once you assign your rights. Now assignment again can be partial or complete. Partial means you are assigning only few rights. The rest of the rights you are retaining or you are keeping with yourself. That is also possible. So that is partial assignment or complete assignment. Complete means what? Completely you are transferring everything, all your rights to other person or a third person. Then fourth is starting a business with a patented product. Many a times, what usually startups or they do, they first see that the product which they are going to launch in the market, first it is protected properly via IP. And once it is protected, completely protected with IP, they launch their product in the market and they start their business with that patented product. So likewise, you can earn money or you can convert your IP into money. So benefits of IP facets to the startup. So now this, as I explained that what exactly is a startup, and you to get the government privileges or different to enjoy the government schemes, you have to register yourself under the portal Startup India, which is again a government portal. Okay, so I mean the registration is not that difficult. Okay, so you have to just enter your and you can do that online also. I mean that is not a big deal registering on this, but it's always better. I mean, of course, you should register yourself for Startup India so that you can enjoy your benefits as a startup, because government is actually helping a lot to the startups. Okay, So patents. So what are the benefits? What benefits IP facet is giving to the startups? Patents protect small startups against the large rivals that have far greater resources. Say a company A, it is having just a 10 to 15, 10 to 20 employees. Okay, it's a startup company. And a company B, which is a big short company, like any IT company, is having more than 1,000 employees. Okay, but company A, although it is having 10 to 15 employees, it is having a particular proper IP portfolio. That is, it has a proper technology. I mean, it has a proper business model. Then it has protected that particular business model with the help of all IP facets. Okay, so in this case, this startup will be much stronger as compared to the company B, which is having more than 1,000 employees, but still its IP portfolio is very poor. So in this case, this particular startup, it can maintain its competitive edge in the market, and it can definitely earn, or it can definitely exploit itself by the way of either selling its IP, acquiring someone else's IP, or licensing its IP. So although these companies, they are big short companies, they cannot, take undue advantage of these smaller startups. Why? Because they are protected. They have protected all their IP facets for their technology. So that is why it is very, very, very important to protect your product or process to different IP facets whenever you are having a startup, so that you can sustain well in the market. Okay, then create unique products and services that have fair chance of success. That itself is an objective of startup. Why you are starting a startup, and whenever you are registering that particular startup under the Startup India, that is a basic requirement of that it should be scalable, it should be a unique business model. So the problems, which there are certain problems in the market, maybe those problems might be in any domain. Okay, might be in any mechanical, industrial, medical, any domain, any sector, healthcare sector, any sector. But if you are having a particular idea to overcome that particular problem, and if you show that fine, this is my particular unique business model, and I am going to implement this model in the market. So in this case, only your startup, the government is going to allow you to register your startup under Startup India. So it should know that fine, this is definitely a scalable business model, this is a unique business model which this particular company or particular startup is going to bring in the market. Okay, so that is why it is very important to protect your IP aspects. Okay, so create unique products. Unique product means what? You have to see what are the problems. See, each and every startup, whenever you start startup, you are very much sure that you are going to that particular startup in which domain that particular startup is working. Say, for example, it is working in healthcare sector. Then what are the problems? In healthcare sectors also there are different sections. So in that, what are the problems? How come my company is going to overcome those problems? So they are going to bring the unique products. Okay, which have again a fair chance of course, whenever a product is unique, it is going to be successful. Okay, so investors, as you know, that see, whenever you have a startup in general, whenever you start a company, you need a finance for that particular company. Initially, at the very initial or at the very initial stage, you can finance your company. You can yourself finance your company. You can ask for capital. You can ask for capital from your family or friends. That is the initial. But when your startup starts growing, say 3 to 5 years, after 2 to 3 years, it starts growing, you are going to need more money to invest. So what you will be doing at this stage, you will be calling different investors to invest in your company. So whenever those investors, they are going to invest in your company, definitely they are not going to invest in your company blindly, right? They are going to look exactly, they are going to conduct due diligence of your company, like what this company is related to. Okay, fine, this is startup, this has been registered under Startup India. If it has been registered under Startup India, then what is that scalable business model which it is going to bring? Okay, fine, so how it is, so what are the different IP facets which it has protected? So has whether it is seeking protection under patents, design, trademarks, or everything. So from that, they will understand that fine, this company is a perfect one to invest. It is protected from all the end. Ultimately, why investors are investing in your company? Because after few years, they want to get more money. If they are investing 1 lakh, after 5 years, they are of course expecting more than that, right? So that is why So investors, if you want to attract the investors to your company, definitely you will have to make the IP portfolio, strong IP portfolio for your company in order to convince the investors what is your business model and what measures you are taking to protect that particular business model. Okay, so likewise, you are going to attract more and more investors to you. Accordingly, you are going to attract partners and collaboration. Once your startup starts growing, it is definitely going to attract more partners and collaborations. Okay, and so this is IP consuming startup. So once you are, say, 5 to 6 years are over and you are in a proper business, well settled business is there, then what you can think of? You can think of acquiring more and more IP. How you're going to acquiring more and more IP? By acquiring more and more companies. So by acquiring company A, you are definitely going to acquire its IP or by either collaborating or by either having a partnership with that particular company. So like market. So that is main objective of startup.
Chitija ma'am, we are not able to. Hello?
Identity.
Ma'am, we are not able to hear you. Hello, ma'am. Chitija ma'am. Yes, ma'am.
Am I audible?
Yes, ma'am. Now you are audible.
Okay,
Hello?
okay. There might be some.
Yeah, there was some network issue.
There might be some internet disconnection problem. Am I audible,
Yes.
right?
Yes, ma'am. Now it's okay.
Okay, fine. So IP management. So what are the different strategies which you are supposed to adopt to proper manage your IP portfolios? Okay. So identification of the IP assets. So what exactly you do while identification of the IP assets? Say for example, I'm the person I want to I'm a person I want to start my company. Okay, as a startup. So what exactly I'm going to do? First, what will be having? I will be having something idea in my mind. I have worked on that particular idea. After working on that particular idea, what I have done, I have converted that idea into a business model. And that particular model or a product, now I want to launch that particular product in the market. But before launching that product in the particular market and before even making that product, first what I'm going to do, I'm going to identify what are the IP assets related to that particular product. Say a particular product is there. Say, let me take the example of, say, ionizer. Okay, I'll give you the example. Ionizer. So it is the product, which absorbs dust particles when kept in a particular room, and it is very beneficial to the asthmatic people. So this is the particular product. Okay, now I am having a particular idea about manufacturing this particular product. So before that, what I'm going to do, I'm first going to identify what are the IP assets in that particular product. So in this particular product, what I'm going to do, the name of the product. So once I decide the name of that particular product, I'm going to apply for the trademark application. Once I decide what exactly is going to be the process by which I'm going to make that product, I am immediately going to file the patent application in the Indian Patent Office to seek patent protection. Thirdly, the design of that particular product. So this is something unique design, which is not available in the market currently. So what I'm going to do, I'm going to register my design under the Industrial Design Registration Act. So likewise, once I apply, I'm not saying registered, because once you apply for a patent or trademark of industrial design, it is going to take some time to get it registered. But even when I apply, I can definitely tell the third party who is imitating my product that, okay, see, I have already applied this for patent, so patent or trademark or say any of the IP facet. So you please don't copy my or imitate my product, say design or logo, anything. Okay, so what I'm going to do, I'm going to first seek this protection under different IP laws. Once I apply for protection under different IP laws, fine. Now my product is ready for launching. Second, freedom to operate check. Freedom to operate check is again done before launching the product into the market. Why? Because before I am launching my product into the market, first I should know that is there anything already available in the market. So that is check is known as freedom to operate. The name itself indicates that whether I am free to operate my product in the market, whether I am entering into the legal boundary of someone else's patent. If someone else might have patented a specific, say not complete technology, but a partial technology, which which even I am planning to patent, first I'm going to search that whether fine. Now this type of product, okay, is this available in the market? The technology which I'm using for that particular product, whether that particular technology is available in the market, or the design which I'm using, or the product which I have designed, whether a specific design is available in the market. So this is a freedom to operate search. So this is also necessary, and it should also be conducted parallelly along with the identification of IP assets. Okay, so freedom to operate check and identification of IP assets, they go hand in hand. So parallelly you are supposed to conduct both the searches. Next one is a due diligence. Due diligence is usually conducted whenever you are giving your particular technology for licensing, or whenever you are merging, or in case of mergers or acquisitions. Okay, while merging or during merger or acquisition, the company with which you are going to merge, or the company which you are acquiring, at this time you should first conduct a due diligence. Means what? You are first checking that company's portfolio, whether that company is incorporated, legal aspects of the company. Secondly, what are the different IP facets that particular company is having, whether that particular company is maintaining that particular portfolio of that particular assets properly. Properly means was whether there are any litigation cases which are even going on related to patents, related to trademark, or there are any infringement cases related to that particular product of a particular company. Is there any infringement suit which has been filed any third party for that particular company's product? So all these checks, they are done before licensing your product or technology, before any acquisition or merger. So that is nothing but a due diligence. Okay, then it's defined ownership. What do you mean by defined ownership? Say me and my friend, they are just having a chat on a coffee table, right? And while having a coffee, we spontaneously we get something idea, and now we get fine, this is a good idea, and we can definitely convert this idea into a particular business. So at this time, whose that particular idea is, whether it's mine or whether it's my friend, or whether we both have developed that particular idea. So this ownership should be defined. Why this ownership should be defined? In order to avoid the legal conflicts while applying for the patent. So while applying for the patent, you are supposed to enter both the names. Okay, so who exactly is the owner of that particular patent? So those names must be entered into the patent document. Secondly, defined ownership is very important while licensing your patent. Whenever you are licensing your product, okay, at that time, this particular clause is specifically mentioned in a licensing deed, that who is the owner of that particular property, that particular intellectual property. Okay, so there should be always a defined ownership. Okay, then third party use restrictions. Usually this third party use restrictions is usually the clause it is added while licensing. So whenever you are licensing, you should add this clause that how much restrictions that particular third party is going to have while using that particular product. So it might be restriction, might be in terms of region. Say for example, I am giving a particular license for I am having a particular patented product. Now I am licensing my product to say 3 companies A, B, and C. For company A, I am putting restriction to use that particular product, say only in Maharashtra. For a company B, I'm saying to, okay, fine, in the north region you can use that particular, use that particular product. Of course, I have given license. Okay, I'm not transferring my right, I'm not assigning that, I'm giving license. So I'm allowing him to use and sell that particular product, say in northern region. And company C, I'm asking that particular company to sell that particular product, say in southern region. So like that, I can third party use restriction. So I can restrict the usage of my particular product in the while applying or while giving the product for license. Okay, IP management strategies must evolve in line with its innovation strategies. This is utmost important point. Say for example, let me say the ionizer. So ionizer is a product. What does it do? It absorbs all the dust particles and then it purifies the air when kept in the room. So this is very beneficial for asthmatic people. Okay, now what I do, I make few changes. Of course, those changes are inventive step. They are the changes, they are the, I have solved few existing problem which are there in the market, and I have brought something new for that particular product. Initially, I have applied for patent for this particular ionizer product, but gradually I make few changes in that particular product and I fail to apply for a patent. So in this case, although I have applied for the patent for a specific ionizer, but the changes which I have made, so solutions to problems which I have made to that particular product, and I have not protected that. So this might be protected some third, it might be protected by some third party, and even to use my product, changes in my product, I will have to take the permission from the third party. It is always necessary that you should parallelly, you should, IP management strategies means what? The time you bring something new to the existing, your existing product, you should always go and protect it first. You should always go and protect it under, say, patent, trademark, copyright, or industrial design. So any type of IP facet. Okay, so you should make proper strategies. And fine, these are the changes I have made to this particular product, and you are supposed to have a protection to that particular changes also. Then and then only you can claim a monopoly right over that particular changes. Okay, so maintaining IP portfolio. Maintaining IP portfolio means what? See, I'm having, for example, say 5 patents, 5 trademarks, 5 industrial designs. Okay, it is not enough that fine, I'm having those. At the same time, I should also see whether I am renewing that or not. For patent, you can renew that either every year, you can renew it for 5 years, it is up to you. But for 20 years, there is a renewal fee. Every year, you're supposed to, although you have got a patent, although you have got a trademark, maybe copyright, maybe industrial design, you are supposed to renew it. Okay, but for patent, you can renew either every year or after every 5 years, it is up to you. So till the period of 20 years, you are supposed to pay the renewal fees after every for every year for patents. For trademarks, you can renew your trademarks after 10 years. So you are supposed to see, fine, out of 5 trademarks, there are 3 trademarks whose renewal date is due. So you're supposed to pay that particular renewal fees, and you're supposed to renew that IP, this trademark. So that is nothing but maintaining IP portfolio. Just having the strong IP portfolio is not enough. At the same time, you have to see that you are also maintaining that particular IP portfolio. Otherwise, if you forget to pay the renewal fees, there is a specific time within which you can restore that. But once that particular time is over, then your particular IP or your particular product, it will be into the public domain. It will get abandoned. It is going to come in the public domain. So maintenance of this IP portfolio is also important to see whether any dates are there, renewal dates are there or not. Okay, and regular IP audits. So like different bank audits and like that. So there are different IP audits also which are conducted for your particular companies. So IP portfolio has been discussed and has been studied by that particular company. And in IP audit, it is also observed that like fine, so this particular patent, so is there necessary to pay the renewal fees? It might happen that, see, I have applied for a patent, I get a patent. After 15 years, I feel that fine, now this technology is not, I mean, there is nothing new in this technology. Much better technologies are available in the market. So at that time, I might say that I don't want to renew that patent for next 5 years. So after 15 years, if I don't renew that patent, my patent is going to come in the public domain. But anyways, even if it comes in the public domain, that is not going to make a vast difference. Why? Because much better technologies are there in the market already. So in this case, I might decide that fine, after 15 years, I don't want to renew my patent. So it is up to me. So likewise, regular IP audits are conducted to just, see whether like what exactly is the IP portfolio, which are already needed or which are not needed, that you can, after you can stop paying renewal fees so that you can automatically they will there in the public domain. Okay, so these are the different IP management strategies which you are supposed to adopt while you are having a startup and while you are protecting under IP facets for different IP facets. Now next, challenges for IP protection. Now there are very misconceptions or misunderstandings about the people that lack, lack of knowledge or awareness that application of IP is a time-consuming process. Yes, it is a time-consuming process, but for specifically for startups, there are many privileges, there are many exemptions. Okay. IP registration is a costly affair. It is a costly affair, but for startups, it is definitely not at all a costly affair because of the introduction of government schemes. So let us see how we can overcome this IP, these challenges. So these are the different facilitation, IP facilitation programs which are being started by the government. So these are the different schemes specifically for patents and trademark. So you are having a patent and trademark facilitators. So what these facilitators do? Say for example, yours is a startup company, okay? And whenever if you go in a particular, say to a particular say law firm, they are going to charge you a lot for filing a patent. Likewise, if you decide to get your patent registered with the help of the patent facilitator. So list of these patent facilitators along with their contact and email details, they are there on our Indian Patent Office database. List of trademark facilitators are also there on the Indian trademark database. In the Indian Patent Office itself, it has everything. So over there, you are going to have everything. So what does this patent facilitators do basically? What they will do that you will have to pay only the statutory fees. Statutory fees means what? Government fees. But the filing fees you are not supposed to pay. That particular fees is given by the government of India to those particular patent or IP facilitators. Patent facilitators. Okay. So you are having a particular, see, I am a particular company, say A. So I want to have a patent of a particular invention. So what I will do, I'll go to Indian Patent Office. I'll see who are the patent facilitators. There are many patent facilitators. I can select any one of them. Contact details are there. Email details are there of that particular facilitator. I can directly contact that particular person and ask him that, see, this is my invention. I want to protect it. So this time what he will say, okay, you have to pay the government fees. Rest thing I will take care of. So the drafting of particular patent application, then the office action, patent application, prosecution, everything, specifically patent drafting, it will be done by that particular patent facilitator and you don't have to pay anything to him. The government is going to pay a certain amount to that particular facilitator. So this is the privilege which you can enjoy, which the startup can enjoy. Okay, then trademark facilitator. Trademark facilitator also, you have to just file the trademark fee and the filing is taken care by that particular facilitators and 50% trademark fee. So the fees which is there for natural person, the fees required for natural person is same for that of startup. Okay, so you can imagine that how much less fee a government is charging for filing patent as well as for filing trademark. If your company, say for example, I'm just take an example of trademark. So for filing a particular trademark, the government fee is 4,500. Okay, so the government fee is 4,500, and if you are a natural person, your fee is 4,500. But if you are a legal entity and not a startup, then you will have to directly pay 9,000. The fee is 9,000 for a legal entity, which is not a startup. However, a legal entity which is a startup is also supposed to pay only 4,500 if it is a registered startup. Then you can only pay 4,500 and you can go for trademark filing. Otherwise, you have to pay 9,000. So this much is the difference between the fees. Okay, so it is always recommended to get your startup registered. These are the different benefits of the scheme you can compare from say year 2006. So in 2016, the startups ecosystem as such was initiated by the government of India, and you can see the number of patents filed in 2016 and how much they have increased in till 2000. This is the scheme. This is under the scheme, not a normal case. The people or the startups who have taken advantage of this particular scheme. Under this scheme, these much are the filings. Otherwise, normally there are much higher filings. This is the people who are taking benefit of this particular scheme. Okay, so you can see the gradual number of increase in number of patents as well as trademarks. So trademark you can see from 4 to 6,070. So there is a vast difference between 2016-17 and 2020, 21-22 filing. Okay, so this is the benefit which you can avail from that. So again, what government, see, fine, government is providing you with a scheme wherein you are you have IP facilitators. Okay, next one is IP facilitation centers. These are the few example of IP facilitation centers which it will help you. They will act as a mentor. They will help you to identify the IP assets. They will even help you to conduct a patentability search, like whether your idea or whether your business model, it is already existing in the market or it is not existing in the market. Accordingly, they will ask you to file for a patent. They will even help you in filing for a patent. So they will act as a mentor. Many of the IP facilitation centers, what they provide you infrastructure, they provide you R&D assistance for your invention. And many of the IP facilitation centers, they also take care after filing process. Say, for example, after filing, how you are supposed to exploit your rights, how you are supposed to make money out of that particular IP facet. They also help you. They also assist you in that particular thing. So these are the IP. These are very few examples. There are many IP facilitation centers. These are just examples. Okay. Next benefit is that request for expedited examination for application. Usually, for whenever you file for a patent, okay, it takes if you file for it, at least it takes 3 to 4 years for your patent to get a grant since the date of filing. Okay, but whenever you file as a startup, you can apply for expedited examination. You have supposed to pay the extra fees, of course, for that to the Indian Patent Office, and after filing a particular form and paying that particular fees, you can apply for expedited examination. Through expedited examination, your examination application gets examined within few months, and you can get even a patent, say within a year from the date of filing. So that is the impact of applying as a startup for expedited examination, and only startups can apply for expedited examination of application. Okay, normal companies, legal entities, they are not allowed to request for expedited examination. Next is patent reimbursement by state governments. So Karnataka Startup Cell, they are providing a financial incentives whenever as a startup you apply for a trademark, and if it gets granted, then they are even giving you reimbursement. So these are the measures they are taken by the government, to boost the startup ecosystem in India. National IPR policy. This was again brought by the government in 2016 with the agenda Rachnatmak Bharat and this why Creative India and Innovative India. Okay, so how much innovative things we can create. So that was basically that was an IPR policy wherein you can boost more and more innovations, more and more inventions that can be manufactured in India. Okay, so what does this national IPR policy do? It aims to incorporate and adopt global practices. So how you can adopt the global practices at national level for the Indian scenario. Okay, undertaking awareness programs, as we know, undertaking awareness programs in academic institutions. Definitely government is playing very important role in this. Then the next is announcement of creation of Indian Intellectual Property Department in the Delhi court. So these are the different types of measures which definitely government is taking since 2016, okay, to boost the startup ecosystem in India. This is the what you can say outcome of that particular thing in global innovation index. So global innovation index, what it is, that how much innovative, what role a particular country is playing in the innovating in the field of innovation. So India, you can imagine, in 2015 it was at 81st position. Now in 2021, in the period of 5 to 6 years, it is now on the 46th position. Okay, WIPO is World Intellectual Property Organization. So in every year it publishes the report in which is known as GII report. GI is Global Innovation Index. Okay, so in that particular there are different, I guess there are 132 or 133 countries which are the members to this, and accordingly they decide what is the ranking of a particular in terms of innovation. Okay, so GII index. And last one, so India is the third largest startup ecosystem in the world after US and China. So you can imagine that this much we have acquired since 2016, and how much more we can acquire after 2021. Okay, so definitely the government's agenda is to bring India at the first position in case of startup ecosystem, and that is why it is coming with more and more and more schemes, so that more and more startups they can take the benefit of that particular scheme. Okay, this was it. I hope you have understood what I have
Yes,
tried
ma'am.
to tell.
Thank you so much. It was a very informative and very enlightened presentation, and we learn about so much about patent. Till now, we have learned about what are different trademarks and all copyright, but you have broad your perspective and how we can approach this for. This is mainly for a startup. How they
Yes.
can approach for the patent? They can approach. But there's one question from my side. What is the expenditure in all?
Can you stop your screen sharing?
Yes, just a minute. Yes.
Yes, ma'am. So, what is the expenditure for a startup? It's all innovative हो गया, product बन गया, and then a person, rural population जैसे बच्चे हैं, गांव के हैं, they are from rural background and they are not able to go there, और वो अपना मुझे इतना समझ में आया कि पोर्टल पे जाके they can register themselves. अभी उनको expenditure एक main issue होगा कि what are the different expenditure patent के लिए especially कितना लगभग expenditure उनको लग जाएगा apart from government.
नहीं, expenditure उन्हें सिर्फ जो statutory fees है. For example, whenever you are filing a complete specification, it is something 1600, right? तो जो forms आप pay जो भर रहे हो और जो application आप भर रहे हो लगभग say 1600 and plus few amount. So that is the only amount they will be paying. But the patent drafting amount which is required for patent drafting, that government is paying to the patent facilitators. So we are not supposed to pay anything to a patent facilitator. We are only supposed to pay the government fees. Rest all is taken care by the patent facilitator. About drafting.
How they will get the patent facilitator? After applying, they will get.
Patent facilitator. See, there are n number of the contact details of patent facilitators. They are available on our Indian Patent Office database. If you go on our Indian Patent Office database, Indian Patent Office website, over there is the list of trademark facilitators. There is a list of patent facilitators. So there are n number of people who have registered themselves as a facilitators. So you can take any contact number and you can directly call that particular person. Ki, bhai, I am a startup and I want to register, since you are the patent facilitator. I want to register my particular product and please help me in doing that. So he is going to ask you, he will just ask you, fine, you pay this much government fees, this much, and it's not very, huge amounts. Basically, the amount, कैसे होता है ना, amount ज़्यादा कहाँ पे लगती है whenever you hire a particular patent agent or whenever you hire a legal this attorney or something, वहाँ पे fees बढ़ जाती है क्योंकि वो drafting और वो जो होता है ना, उसके लिए ज़्यादा fees, patentability search के लिए, patentability drafting के लिए वहाँ पे ज़्यादा fee रहती है. लेकिन since they are the patent facilitators, they are not going to charge. In fact, government gives patent facilitators. Once the patent facilitators files the patent on behalf of that particular startup company, it has to show that, see, this is the patent application number and this is the thing I have applied for. Then the government will pay the fees to the patent facilitators. And that fee is also fixed. I guess it is a 10,000 rupees. The government is also, there is a fixed amount decided, which government is going to pay to the patent facilitator. So you don't have to do anything apart from the statutory fees.
Okay. ठीक है.
ऐसे हो सकता है.
Anyone want to ask some queries? Any student, any staff member related to IPR? आपके चैट बॉक्स में एक फीडबैक फॉर्म भी आपके लिए है, आप प्लीज उस फीडबैक फॉर्म को जरूर से फिल कर दीजिएगा. Is there in the chat box to all the students and faculty members. Okay, there is a one feedback form link. Please fill that. Okay. Any more queries? Ma'am, can you tell me something, because you are in academic, I have seen your biodata. Can you tell me something in academic, how we can go patent for some research? और क्योंकि research ऐसी होती है, research है ना, it is like searching again and again, तो terminology वही है. तो क्या हम जब research कर रहे हैं या research के लिए proposal बना रहे हैं, तो what we should keep in our mind कि वो repeated ना हो, और वो जो है उसका भी मतलब कुछ like some patent is there or not.
तो ये यानी no one should steal your idea, right? While you are publishing your research paper, basically.
Research paper, or I am applying for research, how we can know
Protect
that
yourself.
research is very innovative and all, na?
Right.
Because there are lots of research going on in every field.
Definitely. तो अगर जब आप research कर रहे हो, definitely आप first search करते हो whether the research on which you are doing कि वो already existing नहीं है, right?
Yes.
So in this case, what you will do कि what I suggest कि आप क्या कर सकते हो कि provisional specification file कर सकते हो. तो इंडियन पेटेंट ऑफिस में दो टाइप्स होते हैं, एक कंप्लीट स्पेसिफिकेशन होता है और एक प्रोविजनल स्पेसिफिकेशन होता है. तो प्रोविजनल स्पेसिफिकेशन जस्ट एक इट्स अ 2-page डॉक्यूमेंट वेयर इन यू हैव टू जस्ट गिव द सेंट्रल आइडिया अबाउट योर इन्वेंशन. अभी देखो आपने रिसर्च जस्ट चालू, यू हैव जस्ट स्टार्टेड डूइंग दिस रिसर्च, ठीक है, पूरा कांसेप्ट तो आपके इसमें नहीं रहेगा, फाइन, देयर माइट बी फ्यू चेंजेस आफ्टरवर्ड्स. It might happen that you are making few changes to it afterwards, but you are having a bit summary or a bit central idea of that particular research कि ये है, मुझे ये करना है और ये मैं करने वाली हूँ. So ये हम क्या कर सकते हैं, हम provisional specification फाइल कर सकते हैं, wherein you will seek the आप प्रोटेक्शन मिल सकता है आपको. तो प्रोविजनल स्पेसिफिकेशन हम इंडियन पेटेंट ऑफिस के यहाँ पे फाइल करेंगे, एंड देन once your research is over, but one thing is mandatory that once you file a provisional specification, within 12 months you have to file a complete specification. और complete specification में आपको सब details देने पड़ते हैं, working of your invention or what exactly are the different embodiments of your invention or whatever it might be. What is the best method by which you are going to make that particular invention? It might be anything. So all the details of that particular inventions you are supposed to give after 1 year. So you are having 12 months grace period with you. Okay. Yes, so that is why it is always suggested that you go and file for provisional specification, and then within 12 months you can go and file for complete specification. क्योंकि आप जब provisional specification file करते हो, तब आपको priority date मिलती है. That date is very important because whenever after you file a complete specification, आपका patent वो है वो examination के लिए जाने वाला है, right? So examiner is going to examine that patent application, but at that time, if he finds a similar document, आपके जैसा ही similar document रहेगा, लेकिन जो priority date आपकी है, say for example today is say 23rd June, okay? Yes, tomorrow you are applying for a patent provisional specification, and complete specification you are supposed to file say by 21 June 2023. But अगर आप कल फाइल करते हो और 25th को कोई अगर दूसरा कोई बंदा आके ये कर रहा है, फाइल कर रहा है on the similar research, he can also, so in this case जो आपने पहले फाइल किया है, कल फाइल कर रहे हो, 24th को फाइल कर रहे हो, तो you will get a priority first, and that is why it is a priority date. Okay. So whenever the examiner is going to examine that other person, this your particular he is going to say that, see, this is the person who has already applied, and so you can't do it. Why? Because he is having the priority date. He is the prior person to apply. Yes. So like this is the case. So it is always recommended to go and apply for provisional specification and get the priority date.
Thank you so much, ma'am. Any other query? Ma'am, it was a very informative, very enlightened presentation. You have given very pathway to startup. We are at very initial stage, though we are at very initial stage, but at least दिमाग में एक picture बन जाती है कि आगे क्या करना है, future में क्या करना है. Once we have done this thing, तो एक थोड़ा motivation भी मिलेगा. Yes, and you have explained all about the government policies. बहुत अच्छे से आपने बहुत ही simple language में and very down to earth आपने सब कुछ बहुत अच्छे से layman language को, मतलब हमारे बच्चे जैसे बहुत कुछ जानते नहीं, but they are, I am sure they must able to understand all the steps and precautions and everything. Now I'd like to invite Dr. Shima ma'am for formal vote of thanks. Seema.
Thank you, Shilpi ma'am. थैंक यू क्षितिजा कुलकर्णी मैम. मैम आपका पूरा लेक्चर सुना और लेक्चर सुनने के बाद ऐसा लग रहा था कि हमें कितनी सारी इंफॉर्मेशन नई नई मिल रही हैं, और वाकई में अगर हम कोई भी स्टार्टअप करते हैं या फिर ट्रेडमार्क से रिलेटेड जितनी भी हमें इंफॉर्मेशन आपने दी, सचमुच में बहुत नॉलेजेबल थी। और ऐसे लग रहा था कि हाँ, हम अगर कोई काम या कोई चीजें इस तरह से करते हैं तो वो हमारे लिए कितनी फायदेमंद रहेंगी। जितने भी हम स्टूडेंट्स ने वो सब चीजें सुनी हैं, वाकई में मैम आपने अपना इतना बहुमूल्य समय निकाल करके हमें इतना ज्ञानवर्धक व्याख्यान दिया। सचमुच में मैम हम लोग बहुत लाभान्वित हुए, और आपकी ने जो जानकारियां हमें दी उसमें वो इन्फॉर्मेशन इतनी छोटी छोटी थी, लेकिन हम लग ही नहीं रहा था कि हाँ उनको इतने इंटरेस्टिंग तरीके से जैसे सुन रहे थे तो 1 मिनट के लिए भी कि हम लोग स्क्रीन से हटें। हालांकि कई बार हम लोग ये पिक्चर अपनी ऑफ कर लेते हैं, लेकिन फिर भी आई थिंक सब लोग ध्यान से आपका लेक्चर सुन रहे होंगे। पुनः मैम मैं आपका बहुत बहुत दिल से धन्यवाद देना चाहती हूँ अपने महाविद्यालय की ओर से कि आपका व्याख्यान बहुत ही स्पष्ट और सरल था, जिसने हमें बहुत ही अच्छे तरीके से सुनने के लिए मजबूर किया। साथ ही मैं अपनी प्राचार्य मैम को भी धन्यवाद देना चाहूंगी, जिनके मार्गदर्शन में हम ये व्याख्यान कराते रहे हैं, और इसी श्रृंखला की इस कड़ी में मैम आप हमारे समक्ष थी आज। इनोवेशन काउंसिल के अध्यक्ष डॉक्टर दिनेश चंद्र शर्मा जी का भी मैं धन्यवाद देना चाहूंगी। सर के बिना तो ये व्याख्यान संभव हो ही नहीं पाते हैं। जिस तरीके से सर का टेक्निकल सपोर्ट हम सभी को रहता है, वाकई में बहुत अच्छा रहता है। इसकी उपाध्यक्ष डॉक्टर अनीता सिंह मैम जिस दिलो जान से इस व्याख्यान की तैयारी करती हैं, वाकई में मैम काबिले तारीफ है आपके जितने भी प्रयास होते हैं। कन्वीनर डॉक्टर शिवानी वर्मा मैम का भी बहुत बहुत धन्यवाद देना चाहूंगी। मैं देख रही थी मैम 7 समुंदर पार बैठी हैं, लेकिन कंटिन्यू हमसे जुड़ी हुई थी। शिवानी मैम थैंक यू सो मच। प्रोग्राम कोऑर्डिनेटर शिल्पी मैम तो वाकई में मैम आप नहीं होती तो ये प्रोग्राम हो ही नहीं पाता। आप लगातार इतनी सारी हमारी जो क्वेश्चंस होते हैं, कई बार हम लोग पूछ नहीं पाते, हेजिटेशन फील करते हैं, लेकिन आपने जो दो क्वेश्चन पूछे, वाकई में हम लोगों के मन में आ रहे थे कि हम उन्हें ऐसी कुछ मैम से इंक्वायरी ले, पर आपने हम सबकी ओर से काम कर दिया। थैंक यू शिल्पी मैम। ऑर्गेनाइजिंग कमेटी में नेहा त्रिपाठी मैम, मीनाक्षी लोहानी, अरविंद सर, नितिन त्यागी, आप सभी का भी बहुत बहुत धन्यवाद। साथ ही महाविद्यालय के सभी प्राध्यापकगण जो अपने बहुमूल्य समय में भी हम सबके साथ जुड़े रहे, उन सबका भी बहुत बहुत धन्यवाद। और वास्तव में इस व्याख्यान में वे छात्राएं भी धन्यवाद की पात्र हैं जिन्होंने हम सबको जोड़ करके इस व्याख्यान को सफल बनाने का प्रयास किया है। आप सभी का हृदय से धन्यवाद। और क्षितिजा कुलकर्णी मैम, पुनः हम लोग भविष्य में यदि हमें कोई मौका मिलता है तो हम आपके इस व्याख्यान की नेक्स्ट श्रृंखला या फिर अगली कड़ी भी सुनना चाहेंगे, ताकि हम इन चीजों को अच्छे से सुन सकें। वाकई में मैम आपका सरल व्याख्यान सुन करके हम बहुत ज्यादा लाभान्वित हुए। थैंक यू मैम। थैंक यू सो मच मैम।
थैंक यू।